Thank you all, gentlemen. I really appreciate you coming here tonight and spending the time. And we're going to have a question and answer time. If you have some questions, please feel free to ask. I do also sit on the Redress of Grievance Committee. I'm the sitting clerk. And I definitely take a visceral approach. I'm not as eloquent as these gentlemen. I clean carpets. Okay? I'm a small businessman, I'm a singer, I'm your average guy. But one of the things that really narrows it down is this. If the courts are making rules that are hurting the people, you as an individual, do you have a right to go to that judge and say, Your Honor, this is a bad rule? What do you think? Do you think he's going to listen to you? Exactly. Do you have any authority? The only authority you have is through your legislature. They are your voice. We are your representation. And if we don't have that representation, then we have an unbalanced power. We have a court which has insulated itself from the people. And that is what I've discovered just sitting on this committee and learning from these, and I will say it, great men. And they are my mentors in many ways. And so I see, as a common man, the abuses that are happening to the people. And they're crying. Some people are burning themselves on the steps. Thomas Ball, because he can't get justice. And as Representative Mirski said, and Itse, and Sorg, and Ingbretson, that is our primary function, is to provide justice. So with that, I will take any questions. Please, ask me some questions. Or ask the panel questions. Sir.
Thank you. I saw several of the videos from your website, and I wanted to ask Representative Ingbretson a right-brain question. These are heartbreaking stories. How do you deal with it? You need to be some kind of a therapist or something just to listen to these people, to be empathetic. How do you deal with it?
And you know what? This is going to be a little difficult because we want to record this. So Representative Ingbretson, how do you answer?
You know, I've had any number of chairmen of other committees ask the same question. I don't know. You become a rep because you're empathetic in the first place. And I think the hard part is actually seeing that this person has been without a child for so long, or a child without a parent for so long. And it seems to be wrong in the first place. On the face of it, there seems to be no legitimate reason the person hasn't been found guilty of child molestation or, And by the way, in one of these cases, we had a guy who had lost his kid and hadn't been able to see her for 2 or 3 years. And it turns out that one of our departments that he's coming in with redress to complain against, one of the departments had exculpatory evidence, absolute black and white evidence. And the only reason he got a hold of it was because somebody in the department exposed it to him and just wouldn't tell who they were. But how in the heck was that guy going to get justice? So there's a bunch of stuff like that as well. But I thank you for the question. I find that I enjoy it, and I actually got the best part maybe out of it is you learn to be sort of clinical. You say, just show us what really happened, show us the document, and then the tears come anyway. But that sort of stuff. But the fact is, what are we here for? It's for the people, and if we can maintain it, I don't find it stressful. The other part of it is I actually found I was dealing with like 8 and 10 different departments. I learned more about the government in 2 years than I had in 8 on the Education Committee.
Representative Sorg happens to sit to my left, and honestly, Representative Ingbretson has to kick me to calm me down.
Yes, we have to reel him in all the time.
I'll ask a question that I had meant to ask. That's what I was searching for, so I knew I had 2 questions I wanted to leave you with. This amendment, this proposed amendment, is often presented by its opponents as a separation of powers and a checks and balances issue. We're going to adversely affect the checks and balances between the 3 branches. We all learn about that in 8th grade civics, don't we? So when people say that to me, I ask them, tell me what the effective check is of the legislative branch against the judicial branch. Effective check. We have the impeachment power, we have the power of address, but they're useless because they're so personal. If you have a grievance against the judiciary as an institution, you don't deal with that by impeaching individual justices or individual judges. So it's useless. And Thomas Jefferson said 200 years ago, impeachment isn't even a scarecrow. And we have the power of the purse. And that's true enough. But what are we going to do? Are we going to starve the judiciary? We're just going to zero out their budget and close down the courts? Of course we're not going to do that. So that's not effective either. There is no effective legislative check against the judicial branch now. They've managed to, through a very effective public relations process they've been doing for the last 50 years, insulated themselves. And as Jefferson said, they've made themselves, he was speaking of the federal judiciary, of course, but it's true here now. They've made themselves independent of the state. And we're trying to restore their accountability, which they're required under Article 8 to be. Magistrates are supposed to be accountable. And that's said to be problematical as a separation of powers and a question. So
if you got a question, just yell it out, and then we'll have the person repeat it.
Can I make a...
I'd like a little more elaboration of what is it, Rule 1.2, and how that affects what specific court you're talking about, and where they just say there are no.
I'll quote.
They don't even have to say that. How does that work?
I'll quote the rule. The Supreme Court, under its authority under Article 73B, 73A, has promulgated comprehensive rules for the courts. District Court Rule, however, District Court Rule 1.1 says, as good cause appears and as justice shall require, the court may waive the application of any rule except where precluded by law. So they can decide without telling you why they're doing it. They've just decided justice requires waiving a rule. So in effect, there are no rules. As an attorney, I got out of doing trial work many years ago because I became so frustrated. You go from one court to the other, unless you know the judge intimately, you know his style, you go to a court and you don't know what to expect. I was in a case where not just hearsay, and not just second-hand hearsay, but third-hand hearsay was actually allowed in a neglect and abuse case. The witness testifies, well, he said that, she said that, he said that this happened. And I was just dumbfounded. How do you deal with that as an attorney trying to defend a mother falsely accused of neglecting her child? So that's the rule we're talking about, I think.
Some RSAs that do those cover some rules that the judiciary has to follow, like supreme to their own rules, above their own rules?
Well, I'll talk to that.
Could you repeat the question?
The question was, does the legislature have laws that are superior to the court rules that deal with this issue? And the answer to that is, well, certainly as you heard in the district court, it says that they may waive any rule except where precluded by law. So in the district court, yes, that's true. The same kind of waiver exists in the superior and probate courts in the preamble to their rules, neither of which give the recognition of statute of law. And as we saw in the family court, it has what was just read as Rule 1.1 is Rule 1.2 in the family court, and it does give the recognition of statute, except that if you look at the jurisdiction of the family court, that's all wiped out. You have to understand what an equity court is. And the superior and the superior and probate courts also have equity jurisdiction. It arises out of 15th century English law. The common law having become so complicated, the English Parliament created what they called courts of chancery, which I guess is taking your chances, you know. But that was to be effective. You resorted to courts of chancery because the common law was so complicated, it relied on the last decision in that type of case, and it was just ganglerious. But they were eventually just as bad as the common law, and they were outlawed in the 1800s, about the time that we created the same thing as equity courts in the United States. And equity courts are established for when there is no law to govern the particular circumstance. So when there is no law, the court has the power to do what they believe to be equitable. Now in the superior and probate courts, it is very clearly stated that they have equity jurisdiction in an enumerated list of cases or types of cases when there's no governing statute. Okay, I can buy that. But in the family courts, it says, law to the contrary notwithstanding, they have equity jurisdiction in the following cases, which happen to be all the types of cases that come before them. And so, though their Rule 1.2 gives tacit recognition to statute, their jurisdiction says the statutes are off the table.
Right.
So, and I should say the district court has no equity jurisdiction. They deal only with statute because they are a criminal court. So the answer is, you're pretty safe in superior and probate court. You're very safe in district court in regard to statute, though they can waive the rules. In family court, they are entirely lawless. They recognize our laws just enough to make us think that we have some effect and to keep us off their backs. But that's about to change.
This all gets pretty dense, eh? Gets kind of hard to follow. I want to try to just give you a couple of, help maybe reel some of this in. I get lost in all this. I think Greg Sorg is one of the greatest attorneys I have ever met. And I think it's between he and Itse, you have the enormous constitutional knowledge, and it's a fabulous thing. And if you ever get a chance to spend time with either one of them talking, you could go on for days and you would be fascinated and you would learn more than you could ever possibly imagine. But for all of us, the average citizen, it really is pretty straightforward. I want to go right back to Locke at the very beginning. Locke made his bones in the 17th century debunking the divine right of kings. That's how he made his reputation. And when he wrote two treatises of government, he couldn't very well say the divine power rests in the people, because he just debunked divinity, the divine rule. What he did was he changed the entire dynamic. He took divinity out of it, and he said that you are a free person based upon really your assertion for freedom. These rights you have come solely, pretty much, from a free person has the right of conscience, the right to travel, the right to speak, the right to do all of these things that are in our Constitution. And when you create a free government and you have a consistent of free people, and you write a constitution that says the power always derives from the people, it always resides with the people, you create a legislature that you give all the power to the people's representatives, it's telling you something about our Constitution in New Hampshire, and it's telling you that that is infinitely more important than any claim by any other branch, the judiciary in particular, the judiciary in this case, that they could ever have. How could a judiciary have inherent power? It is impossible in the context of understanding human freedom. You cannot have a free government with an agency, in this particular case, a branch of government, the judiciary, claiming it is free from public oversight. That's the essential message here. No entity, the governor, the legislature is subject to election every 2 years. You don't like us, you throw our butts out. I may have that experience this fall in my own district, and I redistricted myself there. So the people can throw their representatives out in this state every 2 years, every one of them, from governor on down. But when you have a judiciary which is appointed, essentially subject to a good behavior, which is essentially for life unless they're impeached or addressed, and that entity just decides that no matter what the legislature says about it, whether it's security in the courtrooms or any other decision by the legislature having to do with law, rules, etc., if you have a judiciary that says that that's unconstitutional because it somehow violates its inherent power, then what you have done is you've created a king in your courts. So that's the importance of Article 2. The whole point of it is to restore judicial oversight over rulemaking. And I thought it was fascinating. You need to remember, if you talk to anybody between now and the election, that my bill essentially proposed to repeal 73A. To go back to 1977, before we even created this device. And the judges, realizing that scared the bejesus out of them, they went and actually thought about this, tried to develop a relationship, reform or reestablish a relationship between themselves and the legislature. And the justices, proposed this language that's on the ballot. It's their languages. All 5 justices, Justice Hicks, Justice Lynn came to the Senate committee hearing on this subject when it went to the Senate, and they brought that language to the legislature. And the legislature embraced that language. So all 5 justices, all 5 sitting justices, agree with this proposal. At the same time, their sycophants in the judiciary are now coming out saying the judges are somehow intimidated by the legislature, this and that, and they're trying, the rest of the bar, the rest of many other people, including Merrill and Netto and others, and even the Chief Justice, the past Chief Justice Broderick, are saying that this is a bad idea. But you can't give this kind of divine power to your judiciary. You have to retain power over your courts. That's essential. And finally, when you think about critiques and whether or not your justices are necessarily the best person for the job, when Justice Broderick was appointed, he was appointed by Governor Merrill, his law partner. Now, judges are no different from anybody in this room. They're human beings. They have their own interests. They have their own foibles. They have their own prejudices, and some of them are political. So giving that kind of authority to individuals who are not appointed necessarily because they happen to be great constitutional scholars, but appointed perhaps they only have political connections, makes the idea of an independent, unapproachable, all-powerful judiciary insane.
I want to drop back for a minute, and Representative Sorg mentioned Merrill versus Sherburne, and so did Representative Ingbretson. It's really important to understand the structure of our controversies. Now, Article 17 talks about the venue of criminal prosecutions. It clearly gives jurisdiction to the judiciary of criminal cases, the state against the person or the people. And Article 20, which talks about tort law, civil cases, in referring to a jury, also clearly gives jurisdiction to the judiciary in cases of one person against another person. But Article 32, which is the people against the government, is clearly given to the People's Court, the General Court, for its adjudication. Now, what happened for the first 35 years of our republic, almost all law was introduced to the General Court via petition. And the majority of the petitions were in regard to the judiciary. And they were typically losses of due process. One, Mrs. McClary versus I can't remember whom, she was in England, and one of her relatives died, and they held the probate case, and she came back from England and found that the estate that should have gone to her had gone to someone else. And so she entered a petition to the General Court, and the General Court said, gee, there's been a loss of due process here. She wasn't apprised of the hearings. And so what the legislature did was say, judiciary, go look at this again, because there was a problem here. Well, this was pretty frequent. Now, remember I said that the legislature had the power to wipe out the courts. I talked about 1816, 1818, Federalists to Republican Democrat, back to Federalists, and wipe out the judiciary. And what happened was you lost all institutional memory in government. Concurrent with this, all the founding fathers are dying. They've left government. John Langdon is probably the most quintessential. He died in 1819. He had left government in 1813. And the judiciary came down with, you had, I think it was another probate will case, Merrill versus Sherburne, and the petition was entered, and the legislature said do-over. And this was then appealed to the judiciary, and the judiciary said, oh, but this violates Article 37, separation of powers. It's a familiar cry. So the public relations effort that was referred to by Representative Sorg as being the last 50 years has really been more like the last 150 years. Almost 200 years, 1819, we're now 2012. So we're just 190 years of jurisprudence. They said Merrill versus Sherburne violates Article 37 to have this petition answered. And interestingly, in their decision, the court referenced Article 37. They referenced Article 31, which talks about us assembling for the redress of public grievances, and they focused on that word public. They never once in their decision referred to Article 32, which was the people's right of redress before the general court. And they then went on and they talked about Federalist Paper 47, authored by James Madison, and they referred to the writings of Montesquieu. And they said, well, see, Montesquieu talks about whenever one power of government exercises the powers of another branch of government, this is tyranny, and that's how Montesquieu refers to it. And Madison said, this may be termed the very definition of tyranny. You notice they didn't use the whole sentence. What Madison said was, when all three powers of government rest in the same set of hands, whether elected, appointed, or hereditary, this may be termed the very definition of tyranny. By pulling a sentence fragment out and attributing it to the whole, they misrepresented the intent of the authors. Earlier in Federalist Paper 47, Madison describes the same writings of Montesquieu, not a sentence fragment pulled out, but the whole paragraph. And he says Montesquieu was talking about whole agency, the legislature being the judiciary, or the executive being the judiciary, and not partial agency, because he was extolling the virtues of partial agency in the English government. And he then went on to say, and you know what? Of all the constitutions, only New Hampshire got it right with our presentation of Article 37. Because while all the other constitutions of the various states called for an absolute separation of powers, only New Hampshire recognized that partial agency was necessary in order to maintain free government. Let me finish. What they got the people to believe, and they got the legislature to believe, is that the people who wrote the Constitution, ratified the Constitution, and practiced for the Constitution for the first 35 years did not understand it. And it took this enlightened group who had nothing to do with it to properly understand it. And that's the same kind of thing that's going on today.
Well said. Are there any more questions? Yes. Go ahead.
If the courts are acting as if they have this inherent right, what kind of justification do they put forth to justify their actions? How do they justify their actions? What are they?
Why do they justify their action? They justify it using.
Why do they justify it?
They justify it using Article 37. This article that Representative Itse has quoted a number of times, and they completely misinterpret it in their own interest. That's the only thing I can tell you, is they take 37 and they turn the meaning he just described to you on its head. And they say over and over again to the legislature, to the Judiciary Committee, or any other committee where they appear, they take Article 37 and they say that 37 means absolute separation of powers. And it's Orwellian in a sense. And as maybe someone said here earlier, when you read particularly the phrase, as a free government will admit, you cannot have a free government with an autonomous judiciary or autonomous branch of government of any kind. You cannot have it. So Representative Itse's interpretation is correct. You have to have this check. It's uniform among the branches. You can't have a branch that's autonomous, which is what the court says. And what the court has been doing really since the 80s, when it realized that 78A could be abused this way, it's gradually and gradually and gradually gathered more and more power into itself until just a couple years ago. I'm affected by this. I filed a number of bills in the past, in the late 90s and early and maybe 2000, to create an administrative office of the court, to separate the court, to basically have an entity that would do all the administrative functions and leave the judges to working on the bench, pretty much as it does in the United States Supreme Court. And the court regularly opposed that idea until finally, somewhere between 2006 and 2010, they came to the legislature and they proposed creating an administrative office. No, they didn't come to the legislature. I misspoke. On their own, they legislated the creation of an administrative office of the court. They said, without any public hearings of any kind, they created a state agency, in essence. That's a blatant overreach. It's a blatant legislative act. And they've never been called on it by the legislature. So they're willing, they want to coalesce power. Any entity, if you read Machiavelli or read anybody who's written on power, it's always the interest of the persons in power to coalesce, gather power into themselves, wherever they can gather it. And this court has been doing it pretty consistently since 1978 when 73A was adopted. So you watch the court, something you might do sometime. I don't know how crazy about the stuff you could possibly get after this amount of time. But if you're interested, you pick up a copy of the New Hampshire Constitution, and you go to the section that speaks to the judiciary, and you look at the dates of the amendments since about the mid-50s. And what you will see is this gradual aggregation of power from amendment to successive amendment to successive amendment to successive amendment to successive amendment. This is not something that happened just by magic. I think that the idea that they had to somehow get out from underneath public oversight really is strong after the Second World War, and they just worked very slowly over time to accomplish this end. And they, coming back to the beginning, and they use a perversion of Part 1, Article 37 to justify it. It's quite phenomenal once you understand the history and the language of this Constitution. I don't know, we're getting pretty late here, huh?
One last word. I have a case of constitutions in my car.
Oh, good.
So if anybody wants to come down and get one, I'd be happy to hand them out because I get them for free from the Secretary of State. Also, because of Paul Mirski...
Anybody can get these.
Right, yeah. But then you have to drive up there.
Yeah, right.
And I'm going to blame this one on Paul because it's his fault. In 2006, we had a great controversy regarding the ballots. And the legislature had told the Secretary of State how to publish the ballots. And the Supreme Court looked at the ballots, and they had created these super enormous districts in 2002 that had, 12, 13 legislators running in the district. And they said, we have this thing called primacy, that some people, they're going to go into the ballot box and they're just going to vote for the first person they see on the, they're going to go top down. They're not going to figure out, they're not going to take the time to figure out who they want to vote for, which really means they think you're stupid. That's the short interpretation. But because of this, we can't list people's names alphabetically on the ballot beginning with A. So they told the Secretary of State to do something else, and I looked up Article 29, and it says the power of suspending the laws or the execution of them ought never to be exercised but by the legislature or authority derived therefrom to be exercised in such particular cases as only the legislature shall expressly provide for. And so we're making these arguments, and we got the legislature to reconvene itself, and though there were, through some faux pas, we failed to pass the legislation, we did attempt to tell the Secretary of State to publish the ballot as we had told him to, and that's what he wanted. But as a result of that, he said, you're writing all these great constitutional arguments, you should write a commentary on the Constitution. So after all the hubbub was over, I said, did you really mean that? And he said, yes, he did. And so I did the only rational thing possible, being an engineer. I wrote a commentary on the Constitution, which is, by the way, how we found redress of grievances.
Created a monster.
But I have copies of that commentary available. So if you want one, see me down afterward.
We'll close with Representative Sorg.
Yeah, I wanted to answer the question that was actually asked.
We've been learning from
The question, and I remember it too. The question was, how does the court justify what it does, these extra things it does? It does it because beyond just having the power to hear and adjudicate cases, it claims to have inherent powers to do other things too that are like corollary to its core functions. So some years ago, when the legislature passed a law replacing court security with the sheriff's department, the court said no, it's inherent. We have inherent authority to govern the doings in our own courtroom, so they could hire who they wanted to act as bailiffs and guard the courtroom. And they also have claimed inherent authority to regulate members of the bar, which yours truly is a member. And they claim inherent authority to require me to support that organization. What other things have they claimed inherent authority to do over this? But that's the answer. They think anything that is tangentially related to performance of their core functions of hearing and deciding cases, they claim to have the authority to do it. And that's why they've reached out, and so now they exercise legislative and executive powers and claim to be very hurt by the fact that we're trying to call them on it.
Thank you, gentlemen. Thank you, folks, for being part of this event. And thank you, Thomas More College, for letting us have part of this. Remember, vote yes. CACR 26 on the ballot. And question two.